Hello everyone, my name is Judge Eric Davis and I'm the President Judge of the Delaware Superior Court. I'd like to thank you for your service. You're about to see a video about how the Superior Court jury system works. But before I show it to you, there's something I want to discuss and it's important. During your trial, the presiding judge will be giving you a number of instructions. Each day you'll be instructed not to discuss the case with anyone during your breaks or evening sessions. You will also be instructed this duty not to discuss includes any form of social media. Because this is very important, we are showing you this video now. There was a time when the admonition, "do not discuss," was clear. It meant don't talk about the case in person or by phone. In today's world, "do not discuss" also includes X, formerly known as Twitter, Facebook, Instagram, LinkedIn, and all other forms of social media. We are not telling you you cannot use social media while you're on jury service. You may need to use social media in order to keep track of your children's after-school activities, bad weather notices, and the like. We're telling you not to use it to discuss what you're doing, seeing, or hearing as a juror. Do not post what you think of the experience, the lawyers, the parties, the witnesses, or the judge. Do not read anything that anybody else posts about this case. The idea is for you to receive your information only in the courtroom and that the opinions you formulate and develop are only from the information from your own life experiences before you started your jury service. This brings me to another important topic. You will also be instructed not to do any independent research or reading on the internet, in the library, or any other manner. Do not Google, Bing, or Yahoo about this case or any facts or opinions relating to this case. Do not look up information about the parties, the witnesses, the lawyers, or the judge. The idea is for you to receive your information only in the courtroom and that the opinions you formulate and develop are only from this information and from your own life experiences. As you can imagine, many resources are being invested in the trial, both public and private. Each year across the country, cases must be tried again because jurors do not pay attention to or do not understand the judge's instructions not to use social media and not to engage in independent research. Surely you do not want to be responsible for such waste. We'd like to take this opportunity once again to thank you for your jury service, and we hope to provide you with all the tools to make this an efficient and memorable experience. And now, as promised, let's take a look at how the Delaware Superior Court jury system works.
You've been selected for jury duty on Delaware's Superior Court. Many of you are probably wondering how you were selected, how the Superior Court system works, and exactly what will be expected of you during your term as a juror. During the next few minutes, we hope to answer your questions and help you feel comfortable with the duties and responsibilities that come with being a juror. We'll explain the jury trial process, court procedures, and terminology that you may encounter. If you have any questions, please remember them and be sure to ask them at the conclusion of this presentation. Now, before we follow a typical juror through a jury trial, let's take a look at some types of cases that are heard in the Superior Court. The Superior Court is a court of general jurisdiction, which means that cases are initiated as well as appealed to this court. Civil and criminal cases are tried here. They may be heard by either a judge alone or by a jury. A typical civil case involves a plaintiff and a defendant. The plaintiff is the party that initiates a lawsuit by filing a complaint. The plaintiff is complaining about something the defendant did or did not do. The defendant answers the complaint and defends against it. In a typical criminal case, misdemeanor or felony, the state of Delaware prosecutes the case against the defendant. The state charges the defendant with a crime, for instance, robbery, assault, or DUI. The defendant defends against the charge and is presumed innocent until the state proves the defendant's guilt beyond a reasonable doubt. Verdicts in both civil and criminal trials must be unanimous, otherwise a mistrial will result. The constitutions of the United States and of Delaware guarantee a trial by an impartial jury. Your role of juror, therefore, is critical to our system of justice. Even jurors who are at first hesitant about serving later admit that the experience is educational and rewarding. Anne is a bookkeeper. She and her husband live in Newark with their daughter. One day, Anne received a summons in the mail from the Superior Court. She completed the questionnaire and returned it. After review by jury commissioners who determined that Anne was a U.S. citizen, she did live within the boundaries of the county in which she will be called to serve, and she is 18 years of age or older, she is qualified for jury selection. On the summons she received, Anne was instructed to report to the courthouse, where she joined dozens of other jurors awaiting selection for a case. At first, it seemed jury was little more than waiting for something to happen, but actually, many things were happening behind the scenes. Often, a jury's mere presence within a courthouse will cause some cases to be resolved. As Anne and her colleagues sat in the jury assembly room, the judges and attorneys were settling some cases so they would not have to go to trial as scheduled. This process, while it seems like a waste of time, actually saves court time and taxpayers' money. If a case cannot be resolved, it goes to trial and a jury is needed. The selection process is called empanelment. The first step is a series of questions called voir dire, posed to all potential jurors.
Do you know anything about this case through personal knowledge, discussion with anyone, the news media, or any other source? Do you know the defendant or his friends or relatives?
If you answer affirmatively to any of the questions, you will be given the opportunity to go before the attorneys and the judge to explain your answer. If the judge excuses you, your name will not be randomly selected for that trial. However, you may be selected for another case. If your name is randomly selected, you will take a seat in the jury box. You may see attorneys reading from profiles. These profiles contain demographic information about you, such as your name and occupation. They do not contain personal information, such as your address or telephone number. Once the jury box is filled with 12 jurors, the attorneys from both sides have an opportunity to challenge. After the challenging process is completed, alternate jurors will be selected in case one of the jurors must be excused during the trial. There are two types of challenges, a challenge for cause and a peremptory challenge. If an attorney challenges you for cause, it means he or she has a reason for not wanting you to serve on the jury for that particular case. For instance, you may know a potential witness on a personal or professional basis. A peremptory challenge, on the other hand, means that the attorney does not have to state why he or she does not want you to serve on that case. It may be because the case concerns a retail robbery and you are or once were a retail clerk. At no point should you take the challenge personally. And even if you are dismissed from one jury, you may be selected to be a juror on another case. Before we take a look at the trial process, let's take a look at the courtroom and the court's personnel. A typical courtroom looks like this. The jury sits in the jury box. You'll have a close-up view of the entire trial while you decide the facts in the case. The bailiff, wearing a black uniform, will be assigned to each trial and is available to answer your questions and to instruct and assist you. The court clerk handles exhibits, swears in witnesses, and assists the judge and the attorneys. The judge sits at the bench and presides over the trial. The judges will determine issues and law and will instruct the jury. Now that Anne has been selected to serve as a juror on a case, we're almost ready for the trial to begin. But first, she and the other jurors must take a sworn oath or affirmation to give a true verdict according to the evidence. Each attorney is then permitted an opening statement. An opening statement is not evidence, rather it is an opportunity for the attorney to present a brief preview of the case to the jury.
Now, you've heard the prosecutor's account of what happened on the day of June 30th, 2007. Now it is our opportunity to give you our version of the story. As in all cases, there are two sides to each story.
The presentation of the evidence follows, with the plaintiff or prosecutor going first. Afterward, the defendant is permitted to present the evidence. There are several different kinds of evidence that may be presented during a trial, including physical evidence, documentary evidence, and testimonial evidence.
Once I stopped the vehicle, I approached the operator, identified myself, asked for identification and driver's license of the operator of the vehicle.
During the trial, the attorneys may make objections, calling the judge's attention to what the attorney believes to be improper evidence. The attorney will state the reason for the objection, and the opposing attorney will respond. The judge will then make a ruling. If the judge sustains the objection, the evidence may not be considered by the jury. If the judge overrules the objections, then the evidence may be considered. The judge will make his or her decision on an objection by applying rules of law that have evolved over centuries of trial experience. Occasionally, the attorneys will approach the bench to argue points of law or discuss other matters privately. These bench discourses are called sidebars. Sidebar matters are not heard by the jury because they could cause bias or prejudice. When all the evidence has been provided by both sides, closing statements are made. This is a final opportunity for attorneys to argue the evidence already presented and to make a persuasive summation. Finally, the judge will instruct the jury as to the law to be applied to the facts. These instructions are called the charge. It is the duty of the jury to determine the facts of the case and apply the law the judge has given you to those facts. After the charge, the jury retires to the jury room for deliberation. Every jury member is responsible for analyzing the evidence and discussing it before expressing an opinion as to what the verdict should be. You should listen to the arguments of your fellow jurors. In both civil and criminal cases, it is the jury's duty to decide the facts in accordance with the principles of law laid down in the judge's charge to the jury. The verdict must be based solely on the evidence presented during the trial.
Mr. Foreman, please rise. Has the jury agreed upon their verdict?
Yes, we have.
Do you find the defendant at the bar, Billy Thornton, guilty as charged or not guilty?
Once the verdict has been entered into the case's record, your jury duty for that case is complete. Serving as a juror is a job that should not be taken lightly. The judicial system of the United States rests on you. As you take part in this important process, you should remember these 5 rules to perform your role as an honorable juror. 1. Be impartial. A juror must not be biased towards or prejudiced against a party or the case. 2. Listen carefully to all of the evidence with an open mind, and when all of the evidence has been presented, listen and follow the judge's instructions on the law to be applied to the case. 3. Do not discuss the case with anyone until deliberations begin, and then discussion should only be among your fellow jurors. 4. Do not come in contact with any media reports regarding your case. That includes TV, radio, newspaper, and the internet. And finally, 5. Use your common sense. You don't need any special qualifications to be a juror. Just common sense. You are about to take part in a system that is uniquely American and has proven effective for centuries. We trust that you will do your best to uphold our Constitution as you take an active part in our government through the judiciary.
I hope you found this video informative. Should you have any questions, please ask the Jury Services Deputy. Once again, thank you for your service.